Twitter is currently arguing in federal court that it is not liable for illegal pictures of children being hosted off of its platform and for the money it made off of those pictures because of Section 230. Is this the correct application of Section 230? Let's talk about it. I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer, and I'm also a legal and political commentator on YouTube and on Odysee. Wherever you're watching, go ahead, hit that like button, hit the subscribe button. Go ahead and share this out too so other people know this is going on and what Twitter is arguing. All right. I'm going to have to modify a couple of the words in this video for the purposes of YouTube's content moderation algorithm, but let's take a quick look at this headline from Daily Wire, and I'll include the article in the description if you want to check it out for yourself. We're going to borrow it for a second, and then I'll tell you what's going on. Twitter tries to dismiss another cheese pizza case, citing Section 230. Even if allegations are true, we're not liable. So the big question here is, does Section 230 protect a company like Twitter from liability for hosting and making money off of this exploitative material on their websites? And it's a mixed answer. That is actually the design of Section 230. The idea is that, and remember that 230 was written back in 1996, and there's a whole big bundle of problems with that. But the idea was that they didn't want to hold a platform. They didn't want to hold a platform liable for the acts of some of its users, because that way, if they did, a nefarious person could go onto a platform, do a bunch of illegal material, and then the platform would be responsible for it. And that is not particularly fair, since the platform wasn't engaged in the activity at all. The idea was that they would have a good faith attempt to moderate some of this content, and that in doing so, they would be protected from any liability that came up from it. That good faith aspect is part of the problem Twitter has here. Twitter is an entity that has the ability to moderate, censor, and remove material before it even hits the site. It has AI and algorithmic sort of processes that can go ahead and identify offensive, unlawful, or politically incorrect material and remove it. And we've seen this all throughout the 2020 elections. Twitter was very quick, and is still very quick, to remove your content prior to you even posting it if you go outside of their guidelines. So what happened in this case is a couple of kids, they were teenagers at the time, were catfished by someone on social media and induced to provide some illicit photographs. They did that, and then those photographs were used as ransom. When the kids did not comply with the ransom, those photographs were uploaded to Twitter. And as part of that upload, they were subjected to some shame and ridicule amongst their classmates. So once they were informed about this, they told Twitter that this material was out there and that it involved the illegal pictures of minors. Twitter did not do anything about it. In fact, responding to both the minor and the minor's parents that these pictures did not violate Twitter's terms of use. They said that they were acceptable. It was only after well over a week of time and the assistance of a law enforcement officer that Twitter did indeed take down these posts. So the question is, was Twitter actually a passive platform in this case? I would argue no, and that's what the parents are arguing as well in the lawsuit. The idea that Twitter is a passive participant is obliterated by the fact that once they were informed about the material, they were shown proof that the material involved minors, they responded that it did not violate their terms of service, and they chose at that time to go ahead and keep the material up. That is the problem. The other problem that no one's really talking about here is that Twitter and Facebook are actually some of the largest purveyors of this material in the entire world. You've probably seen headlines of various adult sites getting taken down because the discovery of the material on the platform. This material is actually all over Twitter and Facebook, and they know it, and it's a big unspoken problem because these are the social media darlings of today. But here we have proof that Twitter not only is not actively policing against this stuff, but They're not even reactively policing against this stuff. When they're informed of it, when they're provided proof, they are refusing to act. That is the big scandal going on right now. I've talked about this case on live streams, but I've never done it in a short video. Their response here that Section 230 insulates them merited a little video about it. So in summary, recap, yes, Section 230 was designed to provide protection for platforms from this sort of thing. However, accompanying that protection was a good faith promise that they would take measures to remove illegal material, and that is what the protection is actually for. It's supposed to be related to the removal of the material, which Twitter is not doing, in this case, at least not in a timely manner. Oh, yeah, and by the way, they advertised right on it as well. So that is another problem. They're making money off of this stuff. Twitter loves cheese pizza because it makes them money. And it's really, really unfortunate. Anyway, drop a comment down below. Tell me what you think. I'll talk to you next time. Peace. Peace.